Jason, can you hear me now?
Yep, I can hear you.
Okay. How about you, Jason?
I can hear you. Can you hear me?
Yes, very good.
Verizon would be proud.
Yeah.
And you have the PowerPoint to share, Jason?
I do, and I've already opened it up at least once or twice on my end to make sure it works. So when we get started, if it's goofy, when you see it, let me know.
Okay. We're going to give it about another 30 seconds and then we'll get started here. Okay. I want to thank everybody for coming to today's webinar. On behalf of the CLE committee, my name is Anthony Sutton. I am a partner at the Reiter law firm here and a member of the State Bar CLE committee. Before we get started here today on our presentation, I wanted to go over a few items so you know how to participate on today's event and give some other CLE committee public notices. First, do you or another member or law student you know have a drug or alcohol problem or struggle with depression or anxiety? Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with LCL is strictly confidential and privileged. Please call Becky Porter for more information at 605-391-5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. I saw that her information was just shared in the chat, so if you need that, please get it there. You can also call the number 988 to reach mental health professionals or the Sand Creek Employee Assistance Program at their confidential crisis telephone line, which is 1-888-243-5744. Mental health professionals are available at both numbers 24 hours a day, 7 days a week. Today's presentation will last approximately 1 hour. And our topic here today is on fiduciary litigation. On behalf of the CLE committee, I'd like to now introduce our speakers, and I'll introduce them by last name alphabetically. First, we have Pamela Reiter. Pamela is the owner and founding partner of the Reiter law firm in Sioux Falls. Pamela has earned an AV with a preeminent Martindale-Hubbell rating, and is rated by the United States Chambers of Commerce. Our Chambers USA, She's also been named as by Benchmark Litigation as one of the top 250 women litigators in the United States, and is recognized by Best Lawyers America in the areas of trust and estate litigation. Her practice focuses on civil litigation and a lot of times fiduciary litigation. In the areas of trust and estate litigation, she also does business disputes and other complex civil matters. Pamela has served our state bar in many ways, including as a past state bar president, a bar commissioner, president-elect, young lawyer section president, a member of the CLE committee, a member of the lawyers referral committee on the law school committee, and she just finished here a term as the South Dakota Bar Foundation president, and presently also serves on the strategic planning committee. Our next presenter is Jason Sutton. Jason is a partner at the Boyce Law Firm in Sioux Falls and is an experienced attorney who practices in a wide range of areas, including fiduciary litigation. Since joining Boyce in, I believe, 2007, Jason has tried several cases and acted as the lead counsel in both jury and court trials. He's involved in large trust cases and has assisted in a number of internal investigations. He's represented clients, including individuals and utilities, in administrative hearings in South Dakota. He's been involved with several appeals to both the 8th Circuit Court of Appeals and the South Dakota Supreme Court, and has also argued multiple times in front of the South Dakota Supreme Court. Jason similarly has served the state bar in many different capacities, including as a bar commissioner, a member of the Practice Rules Revision Committee, a member of the CLE committee, and in fact has served as the CLE committee chair for several years. If you guys have any questions today before I hand it over to Jason and Pamela here, please post those in the chat. We'll have people monitoring that, and we will have some time at the end of the presentation for questions. And if for some reason your questions aren't able to be answered today, I'll give you some information at the end of the presentation on making sure that you can get those questions to Jason and Pamela and that they can answer that. So without further ado, I want to pass it off to Jason and Pamela, and thank you all for attending this presentation.
Thank you, Anthony. I'm going to start by trying to share my screen because we have a PowerPoint. And the joys of always sharing screens is I can't always tell exactly what you all can see. But starting with that, Pamela, is that the first slide of the PowerPoint?
Yes, you got it.
Okay, we're done now. We've accomplished everything we need to accomplish today. So, in all seriousness, thank you. As we go along today, there's a couple of goals that Pamela and I had as we talked about this presentation. One is the reality is we're the firemen that your clients potentially deal with after things have gone completely pear-shaped and wrong. And so, and I know that glancing at some of the attendees, we've got both, some planners, general practitioners, as well as litigators on this. And so from our perspective, our intent is to try and talk a little bit about the law, a little bit, and probably more pertinent, some of the practical issues that we're seeing in our practice, and then to recognize that how does that one impact on the front end on the planning side to avoid the litigation, because by definition, that's every planner that you've been involved in or planning. And two, if you end up there, what does that look like? What are some of the issues? And, as we go along, we're going to start by talking about generally a little more broadly the concepts of fiduciary duty and the various roles that have that position. But what will become clear is that ultimately what we're really going to drill down and focus on is how fiduciaries are, and the litigation that's spawning out of it, out of really two contexts. One of which is the creation of a power of attorney and an attorney in fact, and the other of which is the growth of trust litigation. And that doesn't mean just the dynastic, big, corporate South Dakota Trust Company type trust. Frankly, that's not really the intent of this discussion. It's, and I'll let Pamela chime in if she, as we go along, we're both going to kind of do that. But, certainly over the last 6 or 7 years, I've seen, and I would anticipate it's just going to accelerate over the next 10 plus years, as you have the graying of rural South Dakota, as well as the transition of wealth and the baby boomers. The reality is that there are a ton of plans out there where mom and dad just put the farm in a trust. And those things are causing all kinds of issues and disputes. And so that's, the legal concepts apply to somewhat generically elsewhere, but kind of the focus on how we're going about this, because that's where we're seeing, at least in my practice, what I would describe as the unintended consequences. And Pamela, before I jump into that, I'd welcome your thoughts and comments on that.
Nope, I think that's exactly right. I think Jason and I practice against each other, and sometimes representing potentially the same person who has different hats. And that's exactly where we're seeing the litigation. So hopefully we can provide the planners some information about what we're seeing, and then, but also be a resource for the litigators out there who are seeing these and trying these cases, or at least talking to clients about their rights and responsibilities.
Pamela raised a good point, and it comes with one caveat. Every time I do any sort of presentation, the litigator in me says I reserve the right to argue the exact opposite of everything I say in this presentation
Me
as
too.
needed. But part of this, one of the reasons Pamela and I, we've done a couple different presentations together, we bring a little bit different perspective, because although we oftentimes, we have cases where we're both on a beneficiary side, or we're both on a fiduciary. More often than not, I'm representing fiduciaries, and her role, at least in the trust world, is much more likely to be addressing the representation of beneficiaries. So we sometimes bring a little different perspective on the issues. So as we go along, if you have questions, please chime in. We want to make sure that this is engaging as possible for you and makes it better for us as well. So start with the law. Who owes a fiduciary duty? And, we're all lawyers. We know that the terms fiduciary duty are thrown out with a lot of different roles within the legal system, but and within the case law. And we've tried to identify some of the various roles that generate a fiduciary duty. Couple of takeaways, whether that duty exists and the scope of that duty are questions of law. That's come out of the Dinsmore case. There's a bunch of the case law that you can deal with that. Now it gets interesting when you start getting within some of these roles. Lawyers is a good example. I've not yet had this fight in a trustee case, but I envision it coming eventually, depending on the allegations of breach. Whether there is in fact a breach of that duty, the court defines the duty, which may have to rely on expert testimony in an odd way to understand, the judge may, what the scope of that duty really is. But then whether there's a breach of that duty, be aware that when you're litigating these issues, may well be a question of fact maybe a question of fact requiring expert testimony. In fact, Judge Schreier just issued a decision in a legal malpractice case opining that the South Dakota Supreme Court in lawyer cases would require an expert to opine on breach of fiduciary duty, which is an open issue. So they're out there. As I indicated, our primary focus today is going to be attorney in fact, as well as trustees. Couple of ones that I think sometimes surprise some people is the real estate broker. I would say keep in mind that there is a caveat in several of these cases that outside of the true fiduciary relationships that we all think of, lawyers, trustees, guardian, conservator, attorney in fact, when you start getting into the broker arena, it becomes a little murkier. The Supreme Court has recognized in the Kaler case and in the Dinsmore case that it is a fiduciary relationship, but as I recall in both of those cases, then the next sentence says, but if it's an arm's length transaction, then there is not a fiduciary relationship. So it may be factually dependent. You run into this in some of the bank cases that are out there that are really fact specific. But I know that when I started looking at this, the real estate broker kind of surprised me. So no, that's out there. Directors and officers. The biggest question anytime you have a director and officer case, particularly if they're in that role, they're going to have a fiduciary duty. But the question is, to whom? Which becomes a very interesting issue and probably dependent upon the facts of your case. And you need to look at it factually specific. Is that a duty owed only to the entity, or is that a duty owed to the individual shareholders? And it may well matter. And the Supreme Court has said, at least in some instances, the directors and officers have a duty to minority shareholders. Now, and they use that fiduciary language kind of, in my opinion, flippantly a bit. What's always been a little unsettled to me is how far does that extend outside the shareholder oppression arena? Because I think logically the duty of the directors and officers is really owed to the entity, not to the shareholders. Just know that that case law is out there and it's a little muddled, perhaps. If you get into it, pay attention to whom is trying to invoke the duty. Who do you owe the duty to? So, what is the duty? It's not the same in every role. That's the takeaway here. We use labels like fiduciary duty, or throughout the case law, there's also, confidential relationship, a fiduciary and confidential relationship. Candidly, I think it sometimes becomes difficult to discern what is a confidential relationship. But they then go on and address, in many of those instances, the corresponding duty. And here's the takeaway I want you to keep in mind is, just because there's a fiduciary duty, you got to drill down on really what does that mean in the context. And the best example that I could find of this when we were preparing this was the difference between a lawyer and a real estate agent. Now, the case law is clear. Both of them have fiduciary duties to their clients, or at least that's what it says. Now, a lawyer, the Supreme Court has further broken down what that fiduciary duty is. It's a duty of loyalty and a duty of confidentiality. Mere negligence, malpractice, if not connected to those duties, I do not believe is a breach of fiduciary duty. And we'll talk later about why that may matter. The biggest issue is the instructions. Real estate agent. Now they define the fiduciary duty in that instance, quote, to use reasonable care, skill, and diligence, and must act honestly and in good faith. So the second part of that, honestly and good faith, that's the duty of loyalty. That makes sense. First part, that's negligence. So at least in the real estate agent arena, looks to me like the fiduciary duty equates to essentially a malpractice claim. So the key is look at your case law, look at the specific duty you're dealing with, and how does that match up with the rule? Okay, self-dealing. Let's deal with general truisms. As a general rule, when you're in a fiduciary, you cannot self-deal. You must act in the best interest to whom you have that fiduciary relationship. We all know that as lawyers. Provided the quote of the Smith-Angus case there for your reference. Just keep in mind there are exceptions. And it then becomes an exception. One, what is the role that you are in? Two, do you satisfy the exceptions authorizing the specific types of self-dealing at issue in your case? Trustees, we're going to talk about that in detail in a bit. I mean, they can essentially, under the South Dakota law, modify, in my opinion, and limit the duties against self-dealing and everything in an absence of bad faith or fraud in the trust instrument itself. Corporate officers. One of the ones you see is POAs. Do they have the ability to make a gift? Can they self-deal? What is the scope of that self-dealing? Lawyers, can we enter into a contract with our client? Well, maybe yes, maybe no. We have to satisfy certain informed consent requirements, and it has to be fair to the client. So, and these exceptions matter because what you're going to hear is breach of one of these, one of the remedies for breach of a fiduciary duty is voiding, not voidable, but voiding the transaction, or at least voidable by the other side. So there's a very real risk that you're going to find out after the fact, and when people are fighting, that the transaction is going to be unwound. So the making sure that you understand the exceptions and where they come into play are huge. So with self-dealing, since Pamela frequently sues my clients for alleged self-dealing, emphasis on the alleged, I'll let her take it from there.
Okay. Thank you, Jason. So I think, to me, one of the issues in fiduciary litigation, and one of the areas that may not be very well defined and it is definitely case specific, is what is self-dealing? I mean, everyone knows if you write a check to yourself and you take money and it's a gift to you, I mean, that's unquestionably self-dealing. Then we come down to the next question of whether it's authorized or not. I think there's an open question out there about whether if you are exchanging value for a transaction is that self-dealing. I think that there is going to be some litigation in that arena, but it's definitely more subtle than just your simple writing oneself a check or cashing in a CD using your power of attorney and putting it in your own bank account. That those kinds of self-dealing acts are pretty easy to define, but there are others where you can get yourself in trouble as a fiduciary. So the factual scenario that we have on the screen today to just visit about, because frankly, I see this frequently in my practice where, dad or mom and I farm together and have for many, many years. That's the way we've always done it. I don't pay rent to farm dad's land and we share equipment. This is a very, very frequent factual situation that comes in my door. Dad's getting older. I'm the one who stayed on the farm, so I'm the natural person to have the power of attorney because I know what's going on. We just keep things going as we always have. Mom and I trust each other. We've run the farm this way for 40 years. And I get half the crop for doing the work. Dad is retired for the most part, so I'm doing the work. So is that self-dealing? The answer is not abundantly clear under South Dakota law right now. It's maybe yes, maybe no. And it depends a lot on the factual circumstances in terms of the relationship, how long it's been going, was the power of attorney used in that farming relationship. So there's a lot of unanswered questions in that regard. And so I think that leads us to the next question. So dad gave me the power of attorney. So now what? And I think one of the important things that Jason and I have talked about for several years now is this idea that it makes sense for the child who stayed on the farm and is running the farm to have the power of attorney because that makes things easy. But one of the biggest unexpected fiduciary duties comes into play there if that child who's on the farm and been running the farm for probably 10 to 15 years, all of a sudden now they have a new duty. And what does that mean? So I think for Jason and me, I think what we would like to say to the planners out there is just be careful and make sure that you're explaining to your clients and to the person who's the power of attorney what their responsibilities are and what unexpected problems can arise. I can't tell you how many times I have the child who stayed on the farm comes in my door and he says or she says, well, I don't know if I'm a power of attorney or not. I think mom or dad might have signed something somewhere. And they're looking around for this document. And sure enough, they find it. And I said, all right, well, has someone explained this to you? Do you know what this means? Have you used this? And all of those, I would say 75 to 85% of the time, the people coming into my office have no idea what their limitations are in terms of being a power of attorney. And so I think that Jason and I have talked about this for years now, that we would really like to encourage people to have that discussion, not just with your clients, but also with the agents that are taking control. Because as a matter of law, a fiduciary relationship exists when a power of attorney is created. But now, so there was a recent case that came down, the Lynch case, estate of Robert Lynch. And in there, frankly, when I was working on that case, I didn't think that the law was exceedingly clear about when when it matters between whether you use the power of attorney or not in a specific transaction. And so what I can say now is that with the Lynch case, I do believe that the question of whether the person was using the power of attorney when he or she did the act that forms the basis for the breach of fiduciary duty tends to be a fact question. And that can take lots of different forms.
And
So,
Pamela, let me chime in one thing on that, because I've had a judge pre-Lynch tell me that it didn't matter that they had not exercised the power, that the relationship is there. And what we eventually convinced that judge, the same judge, I believe, that tried your Lynch case, was that that may be true as to whether the duty is there, but you can't establish causation and damages. So don't forget the other elements if you're out there, you're litigating these cases. Just because there's a duty doesn't mean there's a breach, causation, or damages. Something to keep in mind. We got hold on a second, Pamela. We got a question.
okay.
In the scenario you just described, would allowing the attorney, in fact, to make gifts of themselves in the POA alleviate the concerns on whether the kid breached their fiduciary duty? I assume we're referring to the farm. Go ahead.
Yep. So that's actually where we're going next. So thank you for that question. So first of all, let's just finish up this particular slide. So which I think we have actually finished this one, Jason. So we can now switch to the attorney in fact only has the power stated in the power of attorney. Yes. Okay. And so and that's true. And the interpretation of the power of attorney is a question of law, not fact. That was established in a state of Lynch. And the attorney in fact's powers are strictly construed. And so self-dealing under the power of attorney is only authorized if the document provides clear and unmistakable language authorizing self-dealing. So that addresses the question I think that was just asked. When I was preparing for the Lynch case, what I didn't find was a power of attorney that the South Dakota Supreme Court had found contained the clear and unmistakable language authorizing self-dealing. And so when we were trying the Lynch case, that was an issue that Judge Byrne had to look at, which is, okay, what is clear and unmistakable language of self-dealing? And I'm happy to report that we now have a case that has that language that satisfies that standard. And it is in paragraph 38 of the Lynch power of attorney. And it authorized the agent to make gifts of my real or personal property to such persons, including my attorney or institutions, in such amounts or proportions as my attorney in his or her or sole discretion and judgment may deem appropriate for tax or other reasons. And so that is language that I believe planners can rely upon to meet that standard of clear and unmistakable language authorizing self-dealing.
Pamela, was that language good enough as a matter of law, or was it a question of fact? I just don't remember.
That was, I believe that's as a matter of law. It actually, I know that it was as a matter of law. And the very next sentence after that, the South Dakota Supreme Court said, through the power of attorney, Bob provided Kevin with unfettered discretion to give himself an amount up to the annual federal gift tax exclusion. So that was the gift that was allowed, the self-dealing that was allowed. And I think I've seen several powers of attorney that include that language up to the gift tax exclusion. The question is, do they use the language including my attorney? And so I believe that by using that language, I think that planners could be confident that that's what they're doing. So and in the farm situation, I believe the other situation that would allow and be clear and unmistakable language, and I've seen this in several of the trusts that I have seen. I've seen it in several wills, sometimes in powers of attorney, but typically speaking, it's more for example, the personal representative who is the child who stayed on the farm and is now administering his or her parents' estate. And in there, if the will or the trust specifically says that this child has the authority to rent this piece of ground, and at X percent of the USDA countywide average, I haven't seen any of those situations where there's a challenge to that ability to self-deal, because that's clearly a self-dealing transaction. You are, benefiting as the personal representative or the trustee, but it's explicitly allowed in the document. And so that to me would be clear and unmistakable language authorizing self-dealing, not necessarily in the context of a power of attorney. But okay, so does the POA have authority to make gifts? Yes, if it says so in the document. So the next question that comes up is extrinsic evidence of the principal's authorization to self-deal admissible? Because as typically happens, I have, I represent people on both sides of this issue, people who are accused of breaching the self-dealing rule, and people who are alleging that usually their siblings are violating the self-dealing rule. And the argument used to be under Nash, no, that extrinsic evidence of self-dealing is not admissible to show that the principal authorized the conduct. But the South Dakota Supreme Court has, as they said in Lynch, we have cabined the Nash evidentiary rule in 3 important ways. And those are listed on our PowerPoint, and those come right out of the Lynch decision, where extrinsic evidence is admissible in those 3 instances. And so how are we doing for time? Okay, we're doing okay. But what I would say, what I would advise everyone who's on this call, if you end up in a situation where you don't know if extrinsic evidence is going to be allowed or not, you're just going to have to study the case law on this. There's Lynch, there's Hine versus Zoss, and then there's all kinds of cases that go down this line that are cited. And so it can be a very tricky question. It's not just as easy as by Nash, I win, if I am someone trying to prevent mom or dad's statements from coming in to trial. So just be aware of that, and know that if you're in this situation, there's a lot of case law on this, and a lot of times it's pretty fact specific. One thing I would say, I'm sorry, I want to go back to that just for a second, Jason. So I did think that when we're looking at the extrinsic evidence, it is admissible if under number 1, if you want to see some specific examples of that, that would be in Hine versus Zoss. Number 2, the self-dealing act is outside the fiduciary relationship created by the power of attorney. That is really the Bronson case and Lynch. And that's what we had for the most part in Lynch, is that the court ruled that the self-dealing acts, which were writing checks to himself out of his joint account with his father, he did not have to use the power of attorney to do that. And therefore, they did not apply by Nash to that situation where the principal was managing the joint account, which was unquestionably the principal's funds. So they did not apply by Nash in that situation. And then also number 3, evidence of authorization to self-deal for fiduciary rising outside of an attorney in fact. That would be the Smith-Angus branch case that you could look at for purposes of that situation. Off to you, Jason.
Thanks. And we got a question, but before we jump to that question, one of the things I want to jump off Pamela's comment, the extrinsic evidence issue is oftentimes hugely significant, maybe determinative, because keep in mind that generally when these cases, not always, but when they make their ways to the litigators' offices, it's very common that the protected person is either incapacitated or dead. So they're not going to be able to testify about what their intentions were. And arguably it wouldn't matter anyway, because it's extrinsic evidence. But my point being that, their statements may be the only thing you have other than the instrument. Let's switch to the question before we jump off POAs, Pamela. So the question is, if I represent mom or dad in creating the POA, can I advise the agent they name in the POA? Doesn't that put the planning at risk? For example, claims of undue influence and or confuse who my client is. Should I advise the agent to their own counsel, advise them in their role? You want me to take a crack first?
Well, one thing I would say, and then you can follow up on that, Jason, is I agree with you from the standpoint of giving that advice before the documents are signed. Believe me, when I've got a potential undue influence case coming in my office, the first thing I want to know is, was child at the attorney's office with mom and dad, or mom or dad, when the will or the trust or whatever was created. And so I agree with you that you have to be very careful about that. But my advice to you is, after it has been created, have that conversation with both dad and or mom, parents and child, so that everybody understands what the limitations are, and if there are any amendments that need to be made to that power of attorney after that conversation. That might be where you say, I suppose that does put you a little bit at risk of a claim of undue influence, because you made a change to the power of attorney after that conversation. But that is potentially where you need to have them go to another independent person. But at a minimum, yes, you should advise the agent to go get independent counsel to advise him or her about the limitations, and basically raising the issues for them, because most of the time they literally have no idea that there's even an issue. Go ahead, Jason.
Yeah, I mean, my comment would be, I agree with Pamela about meeting ahead of time. And I'm not sure that I would necessarily recommend you give them advice on what to do and what not to do, because I wouldn't want to create the attorney-client relationship. What I would say is that, one, it's important from a planning standpoint, you talk to your clients. I mean, when they're selecting who they want to be their attorney, in fact, make sure that they understand this. And after it's executed, I don't think there's anything wrong with bringing everybody in and saying, okay, now if here's what this means. I mean, these are lay people. I mean, the whole intent is to make sure that your client, who you're doing the planning for, their intentions are carried out. So let's make sure we're on the same page. Then I would probably follow it up with a letter that reminds, or even ahead of time, say it at the time, and then a letter after the fact that reminds the agent that, I'm not representing you. I can't give you legal advice. And to the extent you have questions about your responsibility in this role, no, there are consequences, there are duties you have, and you should talk to someone else, because that letter is going to be an exhibit later on in Pamela and I's fight, and will make clear they're not your client. Okay. This is okay, let's ask this question. Who has standing to bring a breach of fiduciary duty claim? I can see confusion in the courts on how these claims are structured. Some say it's a private cause that can be brought by any interested person. Others say the cause of action is the decedent and only be brought by the estate. Just curious as to your thoughts on this. We don't have enough time to answer that question. There is a punt. The answer is, I think it depends. How's this for a lawyer answer? And I agree that the cases are muddled. I think it goes back to, who do you owe the duty to? And the best example I would describe of this is in the closely held shareholder scenario. Is it a derivative claim that's only owed, the breach of fiduciary duty is only owed to the corporation, or does it go to the individual shareholders? I don't know that that's necessarily super clear in the law. I think it really depends on what is the quote duty that's being breached, and is that acting in the interest of the entity or not. My sense is, in the lawyer scenario, the power of attorney scenario, the trustee scenario, anybody who can establish that they were in error or otherwise would have received is going to have standing to bring the claim. The recovery may go through ultimately the estate and then be divided out amongst the existing heirs. And then when you start getting into multiple trustees, who has, Pamela and I are acutely aware of an issue about who can bring that claim. But, from my perspective, I think the courts are going to allow the door to be unlocked by anyone if you can establish that you were in fact harmed by the breach of fiduciary duty. Where it gets really technical is, what steps you need to do to unlock that courtroom door. Can you recover your attorney's fees? And does the money go into the estate or does it go to you direct?
And one thing I would say about that, I think it was Elliot who asked that question. To be safe, if you're not sure if you are in a situation where you are representing, for example, an heir to an estate, and you're not sure, or maybe the circuit that you're in, it isn't clear. The way that I've typically handled that is I either have reached an agreement with the other side. Maybe the other side is representing the personal representative, who is the one who's being accused of the breach. Sometimes we have reached agreements where that person steps down as personal representative and my client is either put in that role, or we get an independent third party to serve as personal representative. And then that independent third party assigns the claim to my client, the beneficiary, who's going to pursue it. So there are ways, if you're in a circuit where it's not abundantly clear, that is a way around that issue. And then you don't spend a whole bunch of the estate's money fighting about if you have standing or not. Everybody knows at the end of the day that the issue is going to be, it's going to be litigated, and there's no reason to spend time and money on issues that can be, frankly, resolved. And because if it's the personal representative who you're claiming was breaching the fiduciary duties, and that person is refusing to bring a claim against themselves, I think you've basically established the standing that you need. But try to work with the other side to just not make it an issue and spend money fighting on that issue would be my recommendation.
Okay, so switch to the trust world. Mom asked me to be the trustee of her trust. What now? And it makes a lot of sense, and a lot of times, that if a family decides to create a trust for whatever purposes, and we can argue about whether it makes sense or not to avoid probate, are there estate tax issues, etc. But from a planning standpoint, when if the decision is made to create the trust, you have institutional trustees, and there are very real costs associated with doing that. Trust issues in the sense that it's not the people that are in your lives. And sometimes your clients want, and understandably want, it to be someone, their child or someone they're close to. Much like the power of attorney, just be very intentional in making these decisions. Explain to your client the consequences. Think about the consequences. How does this affect their other roles? How does it affect their, what is their duty? And make sure that, one, when you're selecting that individual in the instruments, that those, you thought about that. And then two, one of the advantages potentially of the trustee side, depending on when you're consulted, is that they've got to accept the appointment. So if you're talking to a client about accepting an appointment, I think it's important that, hey, wait a second, understand here that with this power comes, huge duties. And does it make sense for you to do so? There's a lot of times, or I've had clients say, well, this is what my dad wanted. Yeah, but I can tell you right now, you got a target on your back because you're two siblings who are living out of state and think that you're using the farm assets for a sweetheart deal. So you're right. This is what your dad wanted, but how much does that really make sense? Do you really want to go through this? And I think you need to have that discussion. Now, we're in my practice, and part of this is there's so many of these plans that never see a litigator. So Pamela and I only see after things go bad. So maybe we're jaded, but I mean, there's a couple of things to keep in mind, particularly with small irrevocable and then later revocable or lifetime revocable trusts that we see all the time. One of which is it becomes irrevocable from some trigger event. Maybe one of the settlors died or became incapacitated. And the other one continues to just treat the trust like it's their assets. Darn it, it's our farm. We made it. We can do what we want with it. Well, that's not what the law says and creates a whole slew of problems. Or that, it becomes irrevocable and then you've got suddenly one of the kids takes over or multiple kids, which is not a solution to the problem. Pamela and I are both shaking our heads. If you want to create a mess, make every one of the children a co-trustee and then watch the disaster happen. So be intentional with your clients about what happens with these responsibilities and really what that means. Trustees' duties. You have to act in the best interest generally of the trust, the highest good faith to the beneficiary and any advantage. That's right out of statute 55.2.1. You can read it wholly for the benefit. 55.2 generally describes the trustee's duties. Otherwise, it's spread throughout 55, get into 55.3. Know that most of this is statutorily defined, but the general caveat is in the trust world, keep in mind that almost every one of these duties can be substantially limited in the instrument. So what does the trust say? That should be your starting and ending or starting point on most of it. And then when you're planning, do you want to? I mean, there's advantages and disadvantages. Good faith, personal interest and conflict with the other beneficiaries. This happens in the farm scenario all the time. Same example as the POA that Pamela and I are talking about. Mom and dad decide to leave the farm in at least the land in a trust for the benefit of the 5 children. One child stays on the farm and works. That child's been renting the land at below market value for the last 20 years with his dad on a cash rent basis. He's just continuing to do so. Is that a breach of fiduciary duty if he is the trustee? Might be. That case we've litigated, not to the Supreme Court, but those facts come up all the time. So think about it. Okay, duty of loyalty, can't self-deal, same thing. Use trust for your own profit or other purpose unconnected to the trust. I threw that out there. This is the farm. You're using farm equipment, farm land. This is the default rule, no self-dealing, but that can be changed by clear and unmistakable language. That same buzzword is the POAs. That's the legal test. That's from the Plains Commerce Bank versus Beck case. By the way, if anybody does any bank work and you've not read the Beck case, you absolutely need to read it. It's it definitely caught Plains Commerce's attention. So that's a very interesting case involving where they voided a mortgage because the trustee who signed the document was essentially self-dealing. So the bank's security position was completely wiped out because they had nothing.
And that was even though they had the consent of everyone, written consent.
Yeah, I mean,
and it still voided it.
I hate when this thing does this. Okay. Now, what about transactions that started before you became the trustee? I had a written lease in place with my dad. The general rule and one of the remedies are if you're self-dealing as a trustee, the transaction is voidable. If you're dealing with pre and post appointment transactions, particularly pre, This is also true, but it's less of an issue because you no longer have a fiduciary duty. Those transactions are not necessarily going to be automatically voidable. It's going to become much more fact specific. Did you have a chance to get out from under it? Each time you make a decision, when you're a trustee, that is potentially a separate act, which may or may not be self-dealing. So you have to look at, what was the power to terminate? Was it renewed? Was it not renewed, etc. Duty to manage trust property. This is one of those where individuals don't think about it. It's easy in the farm scenario, but what about the $500,000 that dad had sitting in that savings account? Do I have a duty as the trustee who is the son to do something with that? Is it good enough if that's sitting in a CD? Probably, maybe, I don't know. The general rule is the prudent investor rule. Again, subject to the trust, and you must administer the trust solely in the interest of the beneficiaries. Same idea. Okay. This is where Pamela and my fights oftentimes start. I want, you've got a trustee, and one thing that's unique about the trust world is one of the advantages at times is the secrecy. And that includes that there may not be requirements to provide certain information even to beneficiaries. And beneficiaries, want to know what's going on because they think that the trustee is engaging in a bunch of no good, dirty dealing, or the trust protector or any of the other fiduciaries. And, from my perspective, Pamela can disagree with this, that at times the fiduciaries appropriately think that this then just becomes either a fishing expedition or just a hunt for something to criticize. And so there's this tension of what information do I have to give? What do I want to give? A lot of times my advice to my clients is if it's reasonable, give it anyway, because all you're going to do is force them to sue you and then they're going to get it. But the general rule is that all you have to do as a trustee is give them a copy of the trust instrument within 60 days of either your appointment or when the trust became irrevocable, and promptly respond to any reasonable request for info. And reasonable requests is where the fight is. And that's subject again to change in the instrument. So, and these, information, almost 90% of the cases we ended up litigating really start in the dispute on the information. And so we're very acutely aware of that. So, but Pamela, wait a second, I'm a trustee, but I'm also a beneficiary.
Yeah, hang on. Let me just cover one thing on the information side of that. So this is where Jason and I tend to have a lot of our conversations. That's true. But one thing I would say is that as a person who typically represents beneficiaries, I agree with Jason that 75 to 90% of the things they want when they walk in my door is just information about what's going on with the trust. And I can assure you that if that information is not given to us, my beneficiaries are already at the point where they just absolutely distrust the trustee, you're most likely headed towards court supervision if the information isn't provided to us. That's just how it is. Because then what they say is, well, see, look there. They won't give us the information. I'm confident that they're hiding stuff. And it's we have to go get it. And so, and we're going to talk about trust supervision actions, but basically, I get to use the discovery tools in the rules of civil procedure to gain the information. So to me, it does make sense for the trustee to turn over the information. There's no reason, in my opinion, to be spending the trust money fighting about whether they're entitled to the information related to the trust assets, for example. And so I can just tell you from the beneficiary side that if we can get information, I have been able to satisfy clients when I have been able to just get the information. We haven't even had to go to court supervision. So that's just a plug for that.
Pamela, Jason, you have about 6 minutes left of your scheduled time.
So let's go quick here.
Yeah.
We've gone long, shocker. So I'm a beneficiary. Can't I just, not be a trustee on this transaction and just be a beneficiary?
No.
Yeah, and that's the key. I mean, and this gets really sticky when you have multiple trustees and you have multiple roles. Can they recuse themselves from the board of trustees? I don't know the answer to that question. I don't want to be the one. I mean, just be careful. Okay. So, Pamela, you sued my client and said they were self-dealing. What are you looking for?
Well, depends upon what bad things they did. But if they took money from the trust when they shouldn't have, or if they got a sweet deal from the trust and they shouldn't have, then I'm going to be looking for either a surcharge or damages against your client. And in some situations, like in the Stevenson case, which is cited on the PowerPoint, and the Beck case, I'm going to be looking to void transactions if I can. If there's a way to do it, if it's not a situation where the only remedy is damages, I'll be looking for that as well. We've also got the opportunity to disgorge profits made from using trust property for their own benefit. So, for example, if someone's using the farm and is self-dealing and has no authorization to do so, then their profits that they made on the farm are something that should be coming back to the trust. Disgorging fees received, that's also an option. That tends to be more applicable, I think, to the institutional trustees. I don't see a lot of individual trustees actually taking fees, or if they are, they're usually not that much because they tend to also be beneficiaries of the trust. But removal as a fiduciary is a lot of times. So when we're dealing with this trust litigation, a lot of times it starts with information or my clients think that the trustee needs to be removed and either replaced with a different individual trustee, or sometimes it's just, we just want to have this managed by an institutional trustee because there's just too many fights with it being managed on an individual level. Attorney's fees recovery is also an issue, and we do not have time today to cover that. But there is a lot of attorney fee litigation, 3 cases recently out of the South Dakota Supreme Court on that I would refer you to. And that would include Endress and In re Fred Peterson as 2 that come to the top of my mind.
Okay, so some practical issues to think about when you're litigating these cases. Jury instructions are terrible. For a fiduciary, remember, you're dealing with, if it gets tried to a jury, and it depends on the forum you're in, but 12 lay people are basically going to be instructed that every act that your client does must be solely for the interest of the trust. They are just very problematic in trying and dealing with these cases. So keep that in mind. I'm not usually a burden of proof guy because I think it only matters in summary judgment or it's a tiebreaker, but just know that particularly in transactions between a trustee and a beneficiary where there's a benefit, the burden is flipped. It's the same as with a lawyer. It's the obligation on the trustee to establish that it was fair and proper because there's a presumption that it's without sufficient consideration and undue influence. And again, you may well get that instruction to a jury. So the jury's got the judge telling them that they need to presume that it's unfair. And, and then it's just the practical problems that we've been talking about all day, which is most of these fiduciaries don't ever think about themselves in that role. They just do what they've been doing, or, and even when they're true of heart and not even empty of mind, they just never even crosses their mind until years after the fact when someone raises the problem. And so you got a whole litany of acts that the other side's going to go back through and point at that's inconsistent with their responsibilities. And that's how these cases really, I mean, by the time they get to a courtroom, unfortunately, that's what you deal with. Trust supervision, our last little bit, don't be scared of it. From a fiduciary's perspective, I will tell you, I love supervision proceedings because it allows me to get the court's blessing on a decision we're going to make. And as long as everybody had actual notice, they don't get to sue my client later. So it is important. It's helpful. You know, Pamela can give her couple of seconds from her view on it, but it's there. The options are in 21, 22, and it's a wonderful aspect of the code.
I agree. I think it gives both beneficiaries and trustees the ability to, make their positions known to the court. And it also just helps with the flow of information between the two. And sometimes it results in people being satisfied that their rights have been protected.
So that's the end. We kind of flew through the last couple. If you have any additional questions, I don't know when everything gets cut off, but I mean, I can stick around for a couple of minutes.
Yeah, I think you have a few minutes, Jason and Pamela. So if people do want to ask questions, I think you guys have time to do that. We won't get shut off right away. Otherwise, feel free to direct any questions. If you do need to jump off to that info@state bar question, email address that I posted there, and they'll be able to get that to you. And then I'll hand it over to Jason and Pamela. I do see a question here about slides being available. I don't know if you know the answer to that question, Jason, as being a past chair of the CLE committee. I mean, I think typically that's up to you and Pamela.
I don't have a problem with it, Pamela.
I don't have a problem with it.
I mean, why don't I do this, Anthony? I will email it to you, or I think you have it.
Yeah, I have.
You can coordinate from there. I know they're recording the presentation, so as far as I'm concerned, I don't care.
Yep. Yeah, I'll work. I think if you really want it, feel free to reach out to that info@sdbar.net, and they can work to get you that. But I'll work with the state bar office to ensure that anybody who wants it gets it. So, other questions? Feel free to chime in if you're still on and want to ask your question. I guess I'm not hearing any questions, Pamela and Jason. I'll give you guys we can give another minute if you want. Otherwise, thank you everybody for coming and supporting the CLE committee. We do these Law for Lunches several times a year. So keep an eye out in the bar newsletter for the next one of these. And the typical plug, if you guys ever have CLEs that you would like to see put on, please reach out to a member of the CLE committee. We're always looking for the things that you guys want to learn about and happy to try to gear CLE to what's actually helpful to all of you out there in the field.
Okay. Thank you, everyone. And feel free to reach out to me or Jason, too, if you have questions after this. Not a problem.
Thanks, everybody.